I'm Trevor Morrison. I'm the Dean of the Law School. I want to somewhat belatedly welcome all of you here today for When Seeing Isn't Believing, Deepfakes and the Law. I want to thank all of our speakers and panelists. We greatly appreciate your being here today to take up this tremendously important, and at least if I'm speaking personally, not very well understood problem. So thank you all for being here. We're really thrilled that this is a terrific collaboration, too, between our Journal of Legislation and Public Policy and the NYU Center for Cybersecurity, which itself is a joint venture between the law school and NYU's Tandon School of Engineering. I want to thank, in particular, Danny Shulkin and Lisa Fumia from the Journal, and Randy Milch and Judy Germano from the Center. Thanks for all the work you've done to convene this great event. And now, my main task here is to announce the winners of the 2020 legislation competition sponsored by the Journal. The winners of this competition will receive a prize and travel to Washington, D.C. to meet with lawmakers to discuss their proposals, and then their proposals will be published in Quorum, the Journal's online companion. And so the winners of the 2020 legislation competition are Daniel Lipkovitz and Anna Midori Yamaoka Ankerlin. Congratulations to them both. What did they propose? You'll have to ask them that during the next break and sessions. So next is the final panel of the day, Legislative Solutions, Individual Rights, and the Question of Government Intervention, moderated by our own Randy Milch. I will turn it over to Randy and panel. Thank you. Or maybe I won't. Okay. Hey, how are you? Good to see you again. This is not Randy.
I'm not Randy, sorry, but he is coming. How's everyone doing? Hope you're having a wonderful day. Thank you all for being here today at this conference. Let's give a round of applause to our amazing organizers and service help staff. My name is Amy Larson. I am an associate at Morrison & Foerster, where I work on national security and cyber issues. I'm also a proud graduate of this law school, and a co-founder of Foresight 2020, which is a congressional and Senate training, a cybersecurity defense training for vulnerable campaigns in this election cycle and beyond. You can look us up at foresightpartners.us. We welcome your feedback, and that's available for free to candidates this year and beyond, as we combat all sorts of cyber disinformation threats. As the Dean mentioned, this panel will address larger public policy and legal concerns involved in deepfakes. There are 3 states that have already passed legislation in this area, and several bills, among many bills, currently pending in Congress. Over the next panel, we'll discuss various approaches to regulation and some of the thorny issues that are included in this set of topics, such as privacy, free speech, and civil liberties. We'll also be exploring election and national security issues, digital privacy, and constitutional protections. The panel will be moderated by our very own Randy Milch, who is co-chair of the NYU Center for Cybersecurity and a professor here at NYU Law. Previously, Randy was executive vice president and strategic policy advisor to Verizon's chairman and CEO, having also served as general counsel from 2008 to 14. Before that, he was a partner at a DC law firm and is also a graduate of this fine law school. Please join me in welcoming Randy and the panel.
Good afternoon. I am Randy Milch, or maybe I'm not. This afternoon's panel is going to build on what we heard both at the fireside chat and the first panel. And as the screen shows up there, we're really going to try to deal with the public response. And by public, I mean the public space here, what is government going to do about it, and government writ large. And we have a wonderful panel here with us this afternoon to deal with that. All the way down at the end is Noah Stein from the New York Attorney General's Office, the Bureau of Internet and Technology, to bring us the state perspective. We have Lindsay Gorman from who's the Emerging Technologies Fellow, he's right here, for the Alliance for Securing Democracy, and she has experience at the federal legislative branch, working in the Senate, and also working in the executive branch. We have Rob Volker to my left, who is from Nisos, which is a noted cybersecurity company, and Rob's going to talk to us about the further end of the chain that Catherine put up, talking about making and creating and how to find those people and whether it's possible to find those people. And finally, we have Ben Weisner, who is from the ACLU, and here to ensure that we think about civil liberties as we talk about public response. So what I'm going to ask them to do to start with is to spend 3 to 5 minutes basically giving you their view of the ways in which there could be public response, and then we'll take that as a jumping off point and have discussion here and questions. And there will be time left over at the back end for questions for everybody to discuss these problems. So I'm going to start at the further end. So start with Noah, and then just give us 3 to 5 minutes, and then we'll start our discussion. Thank you.
Sure, thank you very much. So I'm Noah Stein. The New York AG's office has a Bureau of Internet and Technology. My caveat here is that I don't speak for the office. I'm only speaking in my individual capacity. But in my role there at the State AG's office, I am more on the law enforcement side. I bring civil suits against companies or individuals who might be violating New York law, often in sort of a consumer protection role, but I can reach out to other types of law as sort of a predicate offense. So what that means is I've had, for example, a settlement with a company called Devumi that sold fake social media engagement, an investigation into fake government comments in public rulemakings, things along those lines. I'm really interested in what I call mass automated deception and online impersonation. I think these are two areas that have a lot of misuse. Technology's lowered transaction costs for good and also for crime and for fraud. Another area of interest for me is tech-enabled abuse. So things like revenge porn, which is an image that was taken with consent of an intimate nature and then is shared without consent. Stalkerware is a program that you can install on somebody's phone to monitor everything they do and see what they do and spy on them. It's usually marketed to catch a cheating spouse, which is very illegal. And a whole range of other abuses. And I see deepfakes fitting within that context. So there currently isn't a deepfakes law in New York. That said, there are laws already where deepfake use might fit the bill. So criminal impersonation, for example, in the second degree, if you're impersonating somebody and taking an action, then and doing it for a benefit or to hurt that person, then there's an argument that that law covers it, and so that would cover some of the uses of deepfakes. I also wear a policy hat, and I'm interested in legislation. I think we'll probably talk a little bit about that, but that's sort of my background and how I come to this.
Oh, we're going in order.
Yeah,
Okay.
well, we don't have to.
No, that's fine. So I am the ACLU lawyer here, and I know what my role is. My role is to convince all of you that this whole conversation is a moral panic. It's completely under control. Videos are free speech. Even fake videos are often free speech, and that we don't need any new law. So I will try to stick to that, even though it's not actually what I believe. I do think that there are some regulatory gaps, particularly where we're talking about the category of non-consensual pornography, where we have a fair amount of state tort law, but it's inconsistent and doesn't cover all the states. One disadvantage of being the last panel of the day is that most of the smart things that we plan to say have been said better by people that came before us. But I will just offer a few observations that frame my skepticism about jumping into a conversation about new laws aimed at particularly political disinformation. First, as was said this morning, this is not the first time in our history that technology has created anxiety around truth and evidence. Photoshop, which was mentioned, allowed users to manipulate images, and that really did undermine, to some extent, the authority of photography. It required us to turn to context rather than simply content to evaluate truth. And for the most part, our society adjusted to Photoshop and to similar technologies. So for example, if we were to see a photo, of Trump and Putin embracing, if we saw it on Facebook, we would quickly identify it as political satire. If it showed up on the front page of the New York Times, we would all do a double take and wonder if this was something that we needed to consider in a different way. Even before the advent of these deepfake technologies, we learned to consider the source before crediting the content. But of course, in an age of increasing political polarization, our tendency to view the credibility of the source as a proxy for the credibility of the content has become something of a double-edged sword. And this is my second framing observation. At a time when people are increasingly curating their feeds of news to stay in echo chambers, it's not at all clear that consumers of news, at least on social media, care very much about the truth or falsity of their news feeds. They've already made up their minds about what kind of content they want to see, and they're looking for more of it. So for example, I think many of the millions of people who really eagerly embraced the conspiracy theory that Barack Obama was a Kenyan-born Muslim, most of those people didn't particularly care whether that story was true or false. They were eagerly participating in a project of political delegitimization. And I saw something not as extreme, but somewhat similar in my own social media feeds in the year or two after the election, where people would circulate any rumor about Trump and Russia before waiting for credible news sources to evaluate whether it was true. They didn't particularly care. They had already decided that Trump was a stooge who had been installed by Russia, and they were spreading that news around their networks. And this is the thing, people love fake news. And as long as many people, if not most people, are receiving critical political news and information through a business model that is optimized for engagement rather than other important norms, say education, having a kind of set of common facts, it's not going to be easy to get a handle on this kind of problem. And this leads to the third observation, which we've talked about a lot today. This is the liar's dividend, that the deep problem may not in fact be that we'll be fooled by deep fakes, but that we're getting even greater societal license to decide what content is true or false. We've already seen President Trump in a few recent statements introducing the idea that the notorious Access Hollywood tape is a fake and not real, even though he apologized for it in 2016. And we can only imagine what would happen if it turned out that the Steele dossier were true. A video emerged from the Ritz-Carlton in Moscow. I think we know who would believe that video and who would instantly dismiss it as fake without waiting for forensic evidence of whether the video had been manipulated. And again, this is not to discount the possibility that we'll see the emergence of deep fakes that are so sophisticated and subtle that they can even fool the credible media gatekeepers who we have come to rely on. But I do want to say that I think it's important to press pause before we jump into a conversation about what new laws, or particularly what new criminal laws, we need to regulate political deepfakes, particularly when, as we heard on one of the earlier panels, there's no evidence yet whatsoever that this is a serious problem affecting our politics, and we have to reach to the same couple of examples every time, even to illustrate what might be the problem in the future. So that is my cautionary note about legislation, and I look forward to being interrogated about it.
Lindsay?
All right, I'm Lindsay Gorman. I'm the Emerging Technology Fellow at the Alliance for Securing Democracy, and I come at this problem from the perspective of how new technologies, of which deepfake videos, images, and also text and audio, which I think are underappreciated perhaps, how these new technologies shape the balance between authoritarianism and democracy in the global contest and somewhat the ideological contest that is emerging. And I would just like to highlight a few facets of this challenge. I think our organization studies Russian disinformation and authoritarian efforts to undermine the information space more generally. And certainly we've seen the destruction of the information environment within democracies in a way that really plays into authoritarian hands. And following on that, the previous comments about the liar's dividend, one thing that we do know about Russian disinformation strategy, and we're increasingly seeing how this plays out in the tactics in the lead up to 2020, is that the goal is to undermine the very nature of truth itself. The goal is chaos, to make it less and less clear what is true and what is false, and to question whether there is in fact any truth. So with that framing, the question of manipulated images, manipulated videos, poses some serious problems for democracies. It's a framing that is inherently more favorable to authoritarian nations that use information, that weaponize information, and to promote regime objectives, and that don't need an established set of common facts. This is true in the information environment about political candidates, about assessing our leaders. It's also true, as I'm curious to hear from the lawyers on the panel, necessary to an evidence-based judiciary, that we can rely on a set of facts as true, and we can refer to them perhaps in a court of law if necessary. So this is really an area where manipulations to the information space favor authoritarian regimes, and they have an active interest in degrading the very nature of truth. As we've seen, the question of debunking disinformation and false manipulated content is really an uphill battle. I think the adage that the lie travels halfway around the world before the truth gets its shoes on is never been more true. A statistic that I find just mind-blowing from Facebook in 2017, I believe, their top 50 fake news stories, the ones that got the top 50 stories that got the most engagement, the content that was put out debunking these stories got 0.5% of the traction as the original stories. So if we're thinking of this problem as just about putting out content that corrects a manipulated image, a manipulated video, a manipulated text or audio, we're thinking about it the wrong way. And to that end, and I would say in the legislative context, it's certainly not the only solution. Just sort of banning deep fakes, manipulated media, probably will not get at the problem, and may also introduce some problems from the perspective of authoritarianism and democracy. The United Kingdom recently put out an online harms framework that, especially in their initial comment period, really looked at the full spectrum of online harms as a whole, from disinformation to hate speech online to terrorist content. And I think it's important, especially, and I think we'll discuss during this panel, to really separate out what are the challenges that we're trying to address and make sure we're not lumping these all together, because doing so can have deleterious consequences for democracies, not just in our own countries, which are generally strong rule of law nations, but really we're seeing in less consolidated democracies a rise in the prevalence of fake news laws that increasingly put the state as the arbiter of truth. So I think we have to be very careful not to go, and I would probably agree with Ben on this front, not to go over into that ministry of truth category, as we are in fact seeing around the world. But I would say that doesn't mean that there aren't things that the government can do that are not legislative bans. And so I'd be happy to talk a little bit more of those as the panel progresses. But yeah, happy to be here.
Rob.
Great. I just want to thank NYU for inviting us all to this panel, and as well as our friends with Crawl for sponsoring this. My name is Rob Volkert. I work with a cybersecurity firm. So I like to think we kind of bridge the gap between some of the panelists this morning with the social media companies and then our friends down in the government on the left here with NOAA. And I lead a team that does threat investigation, and what that really means in this context is we do a lot of attribution cases specifically for disinformation. So we're not just looking at the content that, ideally would get removed or flagged or something, but we're actually looking at the actors too, and we have creative ways of figuring out who that is, and then we try and figure out, is this a lone wolf, is this a domestic, U.S. domestic actor, is it international actors, is it coordinated, is it not? And so when I think about government involvement in the deepfake space, what I like to sort of focus on are partnerships, and partnerships among whom, and I'll kind of link that into three broad categories. One, I'll call the on-platform solutions, and those are basically your social media, traditional media outlets, a lot of the first panelists there. Two would be I'll call it sort of the middle brokers, which are going to be your cybersecurity companies, your nonprofit watchdogs. There's a lot of investigative journalists, entities out there, as well as law firms. And they may not be tackling the problem directly on the platform like the first category would be, where they have a little more control over what the content can and can't do, and as well as the actual user base too, and the accounts. They are looking at it and they're trying to find solutions off platform. And then finally, the third category would be the public sector and the government entities. And I would just point out that it's not just a US government, I know this has been said before, but it's not just a US government problem, it's also a problem that affects all governments, because essentially at the end of the day, all governments have election cycles. And so what do I think these three matchups can have the biggest impact? Well, one, I'll just say sort of public accountability and information sharing. So if I probably shouldn't assume that no sharing is going on, but I'm going to go ahead and assume. But if there's information sharing between the social media companies and the middle brokers and the government entities, it would be nice to know more about that. So is this problem happening across all platforms, social media or traditional? Is it happening only on one or two? And if so, why are those being targeted specifically? And then also the sort of evolution of deepfake technology as well. What kind of deepfakes are we seeing, and who's using that technology? How is it evolving? Second, who's actually the threat actors behind this? Is it all nation state right now? It can't always be the Russians all the time, I think. Are these criminal actors that are doing this? And I think what we're seeing increasingly is there's a market for actual marketers and hobbyists and tech enthusiasts as well. So part of that then is also determining what is the intent with these actors. So that's kind of the second category. And then third, what can be done about it? So again, I think when the deepfake reaches the social media outlet, sometimes it's already too late, and then you get into the game of whack-a-mole. And someone mentioned earlier this morning that once you can just flood the system, and yes, there's ways of automating detection, but every time you automate it, then you find a way to defeat it, and then you can just flood the system. And there's users that can flag content, there's automated ways, but again, you're always kind of playing catch up. And then there's obviously government solutions as well. So you have your law enforcement options, you have diplomatic options. I just like the idea of even information sharing between governments too, because often we'll see these new technologies emerge in different election cycles, like we saw it in the Ukrainian election before the US election, I believe. And a lot of those are testing grounds. So if we're seeing that happen, or they're seeing that happen, or a social media entity is seeing that happen, they should be sharing that for sort of the next election cycle, or the next government, or the next even social media platform that's emerging. So I'll keep mine short there, and happy to get into these issues as the panel.
Tremendous. Thank you all. So I want to begin today by asking the audience and our panelists to keep in mind Catherine's taxonomy of the life cycle of the problem, because I think it's very useful as we talk about public efforts. And if you recall, it's the maker, creation, distribution, believability, and impact were the 5 stages that she discussed. And I think it's important to keep those in mind, because as Ben says, if this is, or I won't attribute it solely to Ben, if this is not a big problem, you're not going to take as many actions in order to solve it, right? Your action is going to be related to your perception of the problem. And I think that is what makes it very important to think about impact, because impact is obviously brings you to the different types of potential deepfake issues that we have. And you know, we can think about these in terms of either the existing laws or potential new laws. And finally, the whole question of the maker brings in exactly what Rob does to try to figure out who that person is, right? And there are laws and potential laws that affect each one of these categories, which I think will make it important to keep those in mind. So let's start. Let's start with where I think everyone agrees there is a grievous impact, right? And the last panel talked about it as well. And this would be the category of not necessarily pornography, but the non-consensual deepfake of pornography or of sexual intimacy in some way that is used to harass or to denigrate someone, right? First of all, let me throw out here. So, can we assume, is everyone going to nod their head and say this is a grievous impact?
Yeah.
Yes. And everyone's going to nod their head to say Noah's right, that we ought to inflict pain upon the creator of these horrible things, right?
For sure.
Okay, everyone's nodding. How about the audience? Everyone going to nod on that? Everyone's going to nod on that. Okay, we're in a good place here. Let's see how much we really want to do about this. Okay, so let me start off with Noah. Noah, is this against the law already?
It would depend, but yeah, I think there's an argument that it is against the law to take an image of somebody, to have them, you know, to a deepfake where you create an impression that somebody is doing a thing, and you're doing it with the intent to hurt them. You know, I could argue that fits under the criminal impersonation statute. That said, there's never been any case that has said that. It would be nice to have a law that actually makes it very, very clear that that's something that is covered. I think that there is a role for government to come in and craft a rule. It's hard. I acknowledge it's hard, but it can be done.
So what are some of the hard things, Ben?
I just want to say, I mean, this is not a law-free space entirely, although I acknowledge there might be gaps. There are, I think, at least 5 common law torts that would arguably cover that, from defamation to intentional infliction of emotional distress, to intrusion upon seclusion, the right of publicity, false light. I think between those 5, probably most states have some version of that would at least provide for civil liability, assuming the victim could get a lawyer who would take that case. And I realize that's part of the regulatory gap, and I recognize that society might care enough about this problem that they would want to make it criminal as well.
And is there a problem with calling this pornography as opposed to what saying that this is a species of pornography that should be illegal as opposed to something else?
So there in the advocacy circles with respect to so-called revenge porn, there is a sense that it is neither always about revenge nor is it pornography. And I think here with deepfakes, it's fine that we use that as a shorthand to talk about a pornographic use. As I was looking at the statutes that have been proposed, a lot of them use the word pornography without defining it. And if you look at Merriam-Webster, it says that, you know, the first couple of definitions define pornography as something that is intended to arouse. And in a lot of cases, a lot of abuse cases, that is not the intent. It is for sport, or it is to harass, or it is to harm. It might be making somebody look worse without their clothes on than they actually do to try to humiliate them. So there's a whole bunch of nuances that we want to think through. We want to think through those use cases and then try to address those.
Mm-hmm. So Rob, how easy is it to identify the maker of something like this?
Yeah, so what's interesting about that is the individuals or networks that are actually doing these things clearly don't understand or don't care that this is illegal, because I think what they're doing is they're relying on the traditional social media platforms to kind of shut it down for them, and then they just migrate elsewhere. And so some of the research I did with a colleague of mine, Henry Azure at Deep Trace Labs, we were trying to find essentially, is there an illicit underground economy for deep fakes? And what I would describe it as, there is in the context of the non-consensual celebrity pornography primarily, but it's not really underground. So illicit, yes, underground, not necessarily. And what we saw was, the first evolution of deepfakes were hobbyists on Reddit. It was primarily celebrity, non-consensual pornography. And then once Reddit shut it down, then they just migrated to other platforms like Vote, Infinity Chan, 4chan, Discord. So to them, it wasn't so much this is an illegal act. Let's just go find some other place where they care more about, I don't know, First Amendment rights. And so what was really interesting to me is that how freely and open they were. So they could have taken it truly down to the deep or dark web. And what they did instead is they just found a friendlier platform. But they're very open in terms of disseminating tutorials, guides. They'll sort of have almost games where they will determine, the next celebrity that needs to be targeted. And then they'll share images, a lot of image repositories, things like that. So most people don't use their real names on those, but you have to register. And again, then you get into the question of, is the platform itself going to cooperate with whether it's law enforcement or just a user? I mean, most platforms, I think, are pretty friendly to you show them that you're being harassed or targeted. They will take it down. And so what we're seeing is a lot more of, it's less the video being disseminated on the sort of protected forums, as opposed to just the information sharing and the open source sharing, where then they will actually put it on a sort of homegrown or home-owned pornography site in itself. So yeah, is it a one-to-one correlation in identifying someone? Not necessarily, but it's definitely not impossible.
So here's my question. This is a grievous harm. Why shouldn't the platform have to take it down?
Well, I mean, this puts CDA Section 230 squarely in the crosshairs, and this is a conversation that the country is having right now. If the platforms are legally responsible for the content that their users supply, we're going to have a very different internet. And we can choose to have that very different internet. It's going to be an internet that doesn't have Yelp, for example, because if the platform is responsible for the defamatory reviews that users have of the restaurants, then we're not going to have that kind of crowdsource, right? We're not going to have comment sections. We're not going to have social media, because every time someone goes to the platform and says, this content is illegal, the platform will have to take it down the same way they do right now with copyrighted material. Now, if content on a website violates federal criminal law, that immunity already doesn't hold. And there's nothing that prevents federal prosecutors from requiring that platforms take that down. CDA 230 does cover state criminal laws right now, and I think the concern is that the huge variety of state criminal laws across the 50 states would again amount to a kind of notice and takedown regime if you pierced CDA 230 here. But that's the normative answer is that you can't have the kind of open internet that we have right now as an open free speech platform and protect against all of those kinds of harms. Now, nothing in CDA 230 means that you can't go with a warrant to one of these platforms and pierce the identity of who the user is who uploaded this unlawful content and then go after that person with legal process. It just means that you can't hold the platform responsible.
Okay, so you've successfully waved the bloody shirt. Now that we know the internet will be entirely over if the platforms are responsible for taking down revenge porn.
Just a different internet.
But just if they have to take down deepfake porn, the internet will be entirely different?
No. And again, I mean, there have been, so we're beginning to see debates about whether CDA 230 should be amended to deal with particular kinds of content. And we already saw this with online content related to sex trafficking with the SESTA and FOSTA legislation that a lot of civil liberties groups and sex worker groups opposed because of the fear that it would drive those practices more underground and make them less safe. But again, I don't think this isn't a valid debate to have. I question whether it's setting the dial in the right place to make this exception now.
So, Lindsay, I'm interested from your background on the Hill. What would and thinking at the FOSTA-SESTA debate, which was a huge battle that occurred, let's start with revenge. Let's start with the non-consensual pornography, which we all agree is a horrible thing. Could there be a further amendment to Section 230 that's limited to that, or do you think that there would never be the will? And what is it about Congress that makes these things so hard to pass?
Well, I mean, right now, obviously, for obvious reasons, Congress is not really moving on a whole lot. My sense, I mean, I look at it from the election security and election threats context, and right now, we have a Congress that does not want to move on elections because of this political polarization and tying of foreign interference to a particular election-related narrative that is becoming increasingly polarized in a way that's harming, really on a national security basis, a lot of efforts that should have bipartisan appeal. I think, in this particular case, I would be more sanguine about the prospects for any type of bipartisan cohesion if there were support from the private sector, from groups who felt, from companies that, for example, in the advertising space, are not finding their ads on the right platforms, that are the subject of disinformation. I think that would kind of be necessary to bring a bipartisan consensus on this. In terms of Section 230, I suspect you'll get an enormous amount of pushback from the social media companies. There's a sense that they don't want to do anything that will kind of hint at being publishers. But that said, we don't have a huge problem yet with deepfake pornography on mainstream platforms. So there might be appetite for addressing it.
So I allowed us to jump all the way to distribution. I want to take us back one step to we talked about makers. I want to talk a little bit about creation. So creation is the tools, if you will recall, the tools, how it's done, and the like. What is a good public response, an official response on the problem, again, that Catherine pointed out, that there is a 100-to-1 ratio between the intellectual energy that's going into creating the technology to create synthetic media versus the intellectual effort that's going into the detection problem? What sort of public responses could we imagine to that sort of, not just the lopsidedness of that, but is there a public role in reining in the technology itself, or as opposed to the maker? Noah.
Yeah, so I see a model for this with Stalkerware, which I talked about at the beginning. Again, this program that you can install on somebody's phone when they're not looking, and then without them knowing, it is copying everything that they do on their phone, their texts, their location, et cetera, sending it to where the abuser can then log in and see everything. The Wiretap Act, which covers electronic communications too, has some provisions that say it is illegal to possess, sell, advertise a device or program that is designed primarily for this illegal purpose of interception, or that you advertise for the illegal purpose of interception. I think you could probably do something similar. It would be narrow, but I think we could sit down and talk about a way to do that with deepfakes used for trying to impersonate and humiliate somebody. I think we could go after the advertisements, the marketing. We could go after the companies that are trying to design it primarily for that purpose. That's hard to figure out, I'm aware, but it could be done in some instances.
So, Rob, what do you think about it? Given what you know about it, is it? I mean, your statement that so much of this was licit, not illicit, but so much of the technology is just sitting there on enthusiasts, which I think is a very interesting term for that. And would it be bad to make what these folks doing limited in some way by the law? And if it drove it to the deep web, would that be good or bad?
I'll answer that in a couple ways. One, you asked earlier, is there a public response or some kind of regulation of it? I don't think that's possible. I mean, unless you essentially take down open source repositories like GitHub, which is not going to happen. So I think I counted at least 15 to 20 different GitHub code for different types of deepfake technology. And then what a lot of users were doing was just forking that to their own personal page or like a pornography page or just a forum, a topic forum. And so we went down, I was curious just to see some of the entities that actually commoditized it by actually creating websites where they were just automating the process. You pay, I think it was $10 for 5 hours of deep training, or space swapping deepfake training model. And then I was just curious, okay, well, who's actually doing this? Who's the individual behind it? So in that case, it was actually an associate professor, we think, at a Japanese university, who I don't think there was any malicious intent. I think he was just kind of showcasing what he had independently worked on. And then obviously they share this technology on GitHub. Another one was a Russian, probably computer engineer, who that was the one where he had simply forked to a revenue generating sort of ad revenue model where it was a non-consensual celebrity pornography site that was a topic forum, but then the users would upload it and then actually put it on the site, and then clearly they were making revenue off ads. And then another case, it was a user likely based in China that was just sort of an enthusiast or a hobbyist, and they weren't actually selling anything, and I don't know if they were actually generating any revenue, but they clearly were targeting that Asian audience, and it looked like at some point that's essentially where that technology was going to migrate. So can you stop it? I mean, no. And then to your question about is it a bad thing to push it further down to the dark web? I mean, that's a good question, right? Because if you do push it down to the dark web, well, not everyone knows how to get on the dark web. Just right there, you've eliminated a certain part of your audience. Those that do know how, I mean, you have to create account profiles, things like that. You have to use a Tor node. Everyone's paranoid about getting caught what they're doing. And then I think there's also, you just have far less of a marketing audience, right? So, and then you get into sort of a cooperation question too, where if it's on the surface web, again, it doesn't require subpoena all the time. We had mentioned about the counter sex trafficking, and I know Backpage, for example, was actually pretty cooperative with law enforcement with requests. I don't think they were all subpoenas.
I think law enforcement might have a different view.
Well, yeah, right.
We would
fair
definitely have a different.
But if they were cooperative, right?
Yeah.
Then, right, and then what did you do? You shut that down, and then they migrated to not necessarily deep or dark web, but it's a lot harder to go after actors on the dark web. Not impossible, again, but.
Okay, I'm sorry, go ahead.
I would also add in the sphere of what government can do, I think we've talked a lot about reforming laws. But and in terms of detection, I think there is really a role for government investment here to work with the private sector in ways that may or may not exist today to continuously develop better and better detectors. I would push back slightly on a point Rob made earlier that that actors are just going to get better and better and better, and it's impossible to detect this stuff. Not to say that it won't constantly be a contest, but I mean, if you look at cybersecurity as a model, the name of the game on cybersecurity is not to secure your system 100% completely, but merely to raise the bar for the sophistication of an actor to penetrate your networks. So I think a similar analogy is applicable in the case of detection of deepfakes, whereby, yes, of course, you should not control open source code. Many of these algorithms are not such difficult extensions of deep neural networks, and we would do a disservice to, frankly, many of the other applications of artificial intelligence systems if we tried to control that. But that doesn't mean we can't fight against the problem and make it harder and harder for actors to fool the public, make it less and less likely to have a deepfake video or really, frankly, deepfake text that is completely indistinguishable from organic content there.
I want to second that. I will say, like in the data security context, we hear all the time companies will sort of say, well, it's an arms race. Or we hear that actually with everything, with ticket bots, with all sorts of things. And my answer is that when you're in an arms race, the answer isn't to unilaterally disarm. You're stuck in an arms race, and that's unfortunate, but that's where you are, and you invest, and you continue to make it hard. You have to make the transaction costs higher for abuse. Otherwise, people will continue to do it. It has to be expensive to them in terms of time, in terms of money, in terms of risk, of liability. And actually, just one more point, Ben talked about the various tort actions that are available. One of the really horrible things in the abuse context is that trying to vindicate your rights as a victim who has been, had some slanderous image of themselves in a pornographic situation, to make them then go to court and sue and put this image up, it basically makes the injury worse.
But I mean, criminal law does too, right? I mean, you can't prosecute a case without the image. I mean, I take your point that
right.
people might not have the resources to bring a tort case, but I don't think that criminal law solves for that problem.
It doesn't necessarily solve for just that problem, although certainly in the investigation phase, there are points at which you can actually at least start that and provide some more protection for the victim than you could otherwise. So I still think that there is a role for criminal law here, and maybe there's a role for innovative uses of civil penalties so that you're not over-criminalizing, but government needs to step up and play a role.
So I guess, Lindsay, I want to push back for 1 second. Why would we do a disservice to all the good things that artificial intelligence can bring us? Better medical results. I mean, just to name one very obvious area where artificial intelligence has proven to be potentially better than humans at doing it. Why would we do a disservice to all those things if we took directed action at bad people, at bad things that are happening? Why?
Right, absolutely. I mean, I wasn't saying that we don't take directed action at bad people, more that it's impossible to control the code itself. An approach that tries to limit the spread of certain libraries, certain algorithms, is one, an uphill battle because this stuff gets out, not just in our own country, but overseas, and two, would limit that innovation. I question whether that's even potentially constitutional on some levels, but I think that's a different conversation. The tools that are available is a different conversation from the actions using those tools.
Okay, I am added, I used the word bad people. I didn't mean to use the word bad people, because I think we all agree we're going to go after bad people. I want to try to extend us to go after other bad things, and what are the problems with it? They're real problems, I'm not dismissing them. But
and part of that is kind of our open innovation system. This conversation comes up a lot in the context of export controls of emerging technologies, places like China, surveillance technologies, whether it's stalkerware or facial recognition systems. There's I think a reactive tendency to want to control the technology and say, well, we're not going to put that in the hands of these companies who are doing these bad things. And there's a place for that kind of conversation. But if it has to be kind of end user based, the bad people, and it can't be technology driven.
well, but stalkerware is a technology, or the device that is used primarily for surveillance is an illegal device. It's not a matter of that thing. Why can't that be done here?
Well, so I mean, this is this is something I think a lot about. In the case of stalkerware, there initially the laws that governed the interception of communications. First, it was wiretaps, and then when electronic communications came along, they had to update the law to deal with that. And then in stalkerware cases, a lot of the defense arguments were that software is not a device, and sometimes they get a court to agree, and then eventually over time they say that's ridiculous. Of course, it counts. So, yes, we can talk about the technology. It is important, though, to try to get at the underlying harm because the technologies change, and you don't want, this is a place where you have to think about the arms race. You have to think about how bad actors will just adjust the technology to skirt the law. And so you want to try to draft your provisions in a way that allow for new forms of technology. Nobody's perfect at that. It's hard. Laws have to be updated over time, but you can try.
I would just point out, as we talk about the arms race and, the tit for tat, I would also point out there's a lot of potential privacy implications there too. So we're talking a lot about sort of the defensive side and the AI detection methods of once it's actually on the platform in terms of content. But there's also, user identification, which may get to that point if the technology gets to that. So one example would be biometric authentication, right? That kind of scares everyone, but that's a really good way to authenticate someone. There's also one I was reading about 3D imaging authentication, which is basically trying to determine whether the user in the video actually has a 3-dimension to themselves as opposed to a deepfake, which is 2-dimensional. So you can, platforms or, financial institutions is a good one. They can create a lot of different frictions for, making it more difficult for the user to get on, but also make it more secure for the user. But again, are those the sort of privacy things that make people nervous, and is that what we're willing to trade off? I don't think we're there yet, but that's definitely coming, I think.
So I'd like to pivot for a second out of the non-consensual harm, non-consensual pornography or sexual tape, whatever, I don't want to keep on using pornography, to the election context, all right? Which seems to be the area that has people the most, as my grandmother would say, vertutzt, especially coming into 2020, okay? So, and Lindsay, you were very eloquent to talk about the national security issues, the rest. So what do you see if you are generally reluctant to embrace new laws, and Ben, I would ask you this too, what do you see as the appropriate response here? We've had a series of laws, and the moderator of the last panel talked about them, but there have been a number of election-related efforts in the states to limit the ability of, and it depends, either another campaign or some other person to do this, and raises the question of the immediacy of the response, right? These laws tend to rely on someone to go to court to get an immediate order that something needs to be taken down because my opponent's saying something untrue about me. You think those laws are a good idea? You think that there should be some other public response? What are we going to do about that?
So I'm a big fan of the House Ethics Guidance that was published about a month ago now, which recommended, in the sense that an ethics office can recommend, that political candidates and members holding political office not use or share or create deceptively altered content. As a matter of public service, as a matter of principle, pledging not to share this content is one way of stopping the degradation to the information space. And that's not a legal measure, but there is an accountability there. If they've pledged not to share this stuff and they go ahead and do it, there's a public opinion backlash that can happen, and a naming and shaming when candidates deliberately and deceptively share this content. I think the second sort of non-legal, extra-legal remedy is really on the platforms, and they've started to take action here, and we heard earlier today on some of those efforts, which are certainly a strong first step. But exploring potentially a middle ground when you have a political candidate saying, this is a deepfake video or manipulated video, I never said this, I never did this, take it down immediately. I understand reluctance on the part of a platform to do that, particularly in response to one party or the other. The last thing we want to do for the health of our democracy is have our platforms seem politically biased. So that's frankly all the more important why they need to have deliberative policies and procedures that they can refer to, and they're just starting to come out with them. But a middle ground is putting a label up there, much like a disclosure of a political ad saying, paid and sponsored by this candidate. A technical determination of when something has been manipulated is a measure that I'm not saying we necessarily legally mandate that of the platforms, nor perhaps could we, but that's, I think, a responsibility step that platforms can take when they have determined a technical manipulation has taken place in the absence of particular context. It's one thing for a video to appear on the New York Times, as been mentioned, that is the appropriate context, but on Twitter, on Facebook, sometimes we don't have an appropriate context, but we're still getting political news, and that's where I think the platforms can step up and make these technical determinations.
And so you're distinguishing between technical manipulation that is detectable and a determination that something is true or false.
Right, and I mean, no one wants to be in that business, frankly, of determining what's true or false. It's incredibly difficult.
No, it doesn't.
But the technical determination is something that is perhaps an easier waypoint.
So,
Ben, what do you think?
Well, I just want to clarify one thing about the caricature version of my position here. My position is not that this is not a problem, but that focusing on deep fakes is like looking through a straw. That it is a real problem that the predominant internet business model is advertising. It's a real problem that huge majorities of people in democracies are getting their critical news and information about politics from platforms that are optimized for engagement and for keeping them there as long as possible rather than educating them to be better informed citizens in a democracy. And again, I'm not naive here, right? Every newspaper is trying to sell copies to readers. There's always been advertising, but there's something fundamentally different, I think, about the New York Times selling classified ads and wanting to have a big subscriber base, and 80% of the public using two major advertising platforms as their leading sources of news and information. It's a much bigger problem than the one we're talking about, and that's why I think that a lot of the legislative proposals that we've seen are both under-inclusive and over-inclusive. Right, they're under-inclusive for this reason, that if you're worried about disinformation and democracy, deepfakes is probably not the right frame for that conversation. It's much too small. One example that I gave in our green room upstairs before is that worries me a lot. Someone started circulating Spanish language flyers that purported to be from the ACLU that were false know your rights materials for immigrant communities. Right? That is nothing that requires high technology, extremely difficult to combat, very, very, very damaging, but can't be captured by any of these kinds of conversations. They're over-inclusive because, these technologies are being used effectively for satire, for parody, and it's really hard to put government decision makers in the role of trying to say, which one of these ads is a deceptive one and which one is just, sharp-elbowed, funny politics. Even words like manipulation, someone else might use the word persuasion to describe the exact same content. And if you look at our politics going back decades, particularly political advertising, I think manipulation is a word that would fit on a lot of the ads that we saw before, but there's a new fear in the tech context. So I worry that we will capture content that actually is protected and therefore chill appropriate uses of this and not actually even get at the real problem.
Right, so we are at about 15 minutes left. I have more questions, but I do want to open the floor up to the audience. If folks have questions, we have one over here, and we have one over there. So why don't we get and if we don't have the microphones, just shout it out, and I'll be sure to repeat it.
Okay, so actually, I'm really glad to ask this question right after Ben spoke, because one thing that's bothered me in both panels is no discussion of the ongoing antitrust discussion in the country and investigations. And it seems like this definitely has a bearing on threats from deepfakes and also from other technologies. So I would just be curious for sort of short thoughts on the antitrust debate and thoughts about market structure with respect to this problem.
Did you all hear that? The question was about antitrust, whether there's a efflorescence of new antitrust concerns about the platforms. They're not necessarily new. And how does that, in your mind, play into this debate, the market concentration of the platforms, et cetera?
Yeah, what, you want to go? Or?
I'll go,
Yeah,
I can
go
be
ahead.
quick
Yeah,
because our office has antitrust investigations into 2 major platforms, Facebook and Google right now, with some other states, so I can't talk about that. That said, what I can say is we don't necessarily need to resolve the antitrust. I mean, I understand and accept what you're saying, that of course the bigness issue there might correspond in ways to other issues, but we don't have to only worry about antitrust enforcement. We should certainly also address these problems in other ways. We should be talking to the platforms about doing more and, you know, encouraging them with the efforts they're already taking, regardless of the outcome of any antitrust investigation.
Obviously, I'm very concerned about 80% of Americans getting most of their news and information from 2 companies, right? That is a major concern. I don't think current antitrust law, in the US at least, has a framework for dealing with that problem, for when a company like that is very good for an individual but very bad for society, right? European competition law is probably where the action is going to be here, where they're coming up with different definitions of harm that don't rely on whether something was less expensive for you as an individual, but actually look at the effect that this company is having, both in an ecosystem, but also on our society as well. So, yeah, I'm not hopeful that the as long as we have that basic fact, right? As long as we have people not turning specifically to news sources, but turning to their social media platform for their news and information, that we're going to make much of a dent in the misinformation and disinformation problems.
There's a question over here. I'm sorry, did I interrupt?
Oh, no, sorry.
No, go ahead. Go ahead.
Hello. Just on the conversation that you had earlier, a lot of the actual worst case scenarios, in my experience, are kind of covered by criminal law if you try and attack somebody online or this and the other. What I'm curious about is how, if these videos land in an echo chamber, they get propagated out and they strengthen views within the echo chamber, drive confirmation bias and cognitive dissonance. I'm curious as to whether or not the focus should be on the content algorithms, content curation algorithms, rather than the deepfake algorithms, because the deepfake technology in itself isn't harmful as such. It's the application of it and the targeting of it at certain groups. Just curious to get your views on that. Go ahead.
Yeah, sure. I definitely think we need a much harder look at the content curation algorithms and specifically understanding we understand that engagement is a huge metric, but beyond that, how are platforms making determinations on what's shown is really non-transparent right now. And thinking from the foreign interference, from the national security context, that has some pretty dark problems as well. Maybe not in the same way as non-consensual sexual imagery, but from the information manipulation side, having these content curation algorithms be non-transparent opens us up to censorship, to downplaying content that is seen as politically offensive. There have been certainly reports of the Chinese social media platform TikTok censoring content, or not even necessarily removing content, but downplaying it in the algorithm, content that was related to the Hong Kong protests, to the Xinjiang human rights situation. So I think it's a broader threat to our democracies, not having visibility and a window in to how these algorithms are prioritizing information, so that we can actually draw a clear line between the algorithms and these echo chambers that you mentioned. And I think there are analogies to be made potentially around auditing from the financial services space that would not necessarily open up the books. I don't think anyone would really reasonably say, let's display the algorithms, these proprietary algorithms for the world to see, but a little bit more understanding on what are the actual factors beyond just engagement, or for YouTube's case, watch time, session time, that goes into this prioritization would go a long way, I think, to at least advancing our understanding of how they are affecting our discourse, because right now we're pretty much in the dark.
You could also open them up, the companies could open them up to researchers. Right now, researchers can't really dig into it without violating the Computer Fraud and Abuse Act and risking civil and criminal liability if they try to run their own tests on these platforms, which require them to sort of use false accounts and create the way that we do offline testing in the real world. So I think that there has been pressure on the companies from civil society and media to at least open this up to some people who can research it without actually publishing everything.
Wait, we have another question?
Sure. So, Gabe Ramsey with Kroll and Mooring. Heard a couple of discussions today. We've got technical mitigation solutions. Is this algorithm creating something that's manipulated or not, and detecting that? Another bucket of mitigation solutions that are about truth versus falsity, whether one can know that or not. And sort of baked into all of that is both of those things are really hard in the abstract, just based on the content. And so one conversation is, should we just push all this obligation to the platform owners and undo CDA a little bit in some narrow bands here? And I've heard distaste about that. I find it an interesting irony that the ability to actually make determinations about truth versus falsity or integrity or not in content is hugely informed by whether you know who the speaker is or not. So looking behind all this, and maybe this is Rob's point a little, is if you can get to attribution, if you can get to the actor who created the content, you learn a lot more, and you're way more well-tooled to know whether it's true or false. And I'll observe it opens a huge irony, right? All the tools you need to get to attribution in this environment are as intrusive as shifting all the burden to the content owner to make those hard choices. Any observations about that tension?
Yeah, those are all good points. One thing I would point out is sort of which we didn't really talk a whole lot about here, was sort of the revenue generation part of this. So, we talk a lot about, I think, or focus a lot about on nation-state actors. And again, getting back to that partnership idea of, synchronous sort of internal telemetry data from the social media platforms as sort of leads points that could be shared with researchers or cybersecurity firms, and then ultimately the government and all the government tools. And so if they can point to the nation-state actor, that's great. We should know about that. There's obviously, hopefully, some mitigation options there. But then there's also the revenue generation part of it. And the reason I bring this up is because when you get into a lot of foreign election cycles, the entities that crop up that are attributable, they don't necessarily think that there's anything immoral about it. They don't think there's anything illegal about it. And you'll see sort of this whole micro ecosystem rise up in preparation for election cycles, whether they're social media influencers, whether they're actual marketing companies. A lot of them just try and create mass accounts to defeat the terms of service and the detection systems of social media platforms anyway. So, you can get to the attribution, and again, I think that's really important when you look at, okay, is this directly connected to an election cycle? Is this worth sort of everyone's time from the social media platform to the government? Is this a United States government problem? Is this a foreign government problem? Now that we have the major platforms globally expanding, is it their problem as well? But I think that speaks to the value of the attributing the actors themselves, because I think you can really get to the intent, and then I think via the intent you can kind of determine, okay, is there a criminal activity here? Is there really any ability to stop the problem at all?
Yeah, and I would sort of second that and say that particularly in the context of foreign interference and a foreign nation-state actor, that attribution is essential. And maybe changes the game a little bit when we talk about some of the mitigations here. There's certainly a sense that within a democracy, a diversity of voices and an open debate is a good thing, but foreign interference in elections is not. And so one actually legislative proposal that the NDAA, the National Defense Authorization Act, this year puts into place is asking the Director of National Intelligence to actually report on instances of foreign uses of deepfakes. Right now, I don't think we've seen any to interfere in the United States election, but if we were to, we would not really have the tools to go and look for it, and that's what this provision, I think, tries to do. And I would hope that that involves some coordination with the private sector, with firms like Rob's, to really go in the weeds and dig into how our nation-state actors thinking about using these tools, which are not just videos. There's certainly a body of research from Chinese machine learning experts, and I'm sure others, that tries to create synthetic comments to social media sites. That, I think, should also be part of this holistic analysis that I hope the DNI will do.
And it bears mentioning in this context that the leading federal proposals to create new liability for deepfakes expressly exempt the American intelligence community. So when we talk about foreign interference, it really depends on where you're sitting.
All right, we have time for one more
Hopefully-
question.
Hopefully they include domestic interference too in that. And on a serious note, a lot of U.S. domestic actors are learning from, foreign interference type activities like the Russian IRA, and then they're just emulating that. And so they didn't necessarily do it in 2016, but we're definitely seeing that happen as it gets closer to 2020. So.
Wait, I need to jump on that too, because that absolutely is another reason to have laws that hold people accountable. After the 2016 election, there was a lot of journalism and other efforts to understand what happened with online propaganda, and a researcher that I spoke with talked to a bunch of digital strategy firms, political consulting firms, and they said, well, it's the Wild West, we do what we want. And they were manufacturing fake content. Now, was it effective? Who knows? But you don't want that to be the case. You really don't. And so we need to find ways to say what is not acceptable.
All right, on that note, on the need to find ways that are not acceptable, thank you very much. I want to thank the panel.
Hi, everyone. My name is Chris Shenton, and I'm the incoming editor-in-chief for the Journal of Legislation and Public Policy. And on behalf of all of us at the Journal, I'd like to thank you so much for coming and staying attentive and engaged and asking super interesting questions throughout the day. Also want to thank our co-sponsors, the Center for Cybersecurity, as well as some of our supporters, Kroll and Moreling in particular. This would not have been possible without you, so thank you. I'd also like to thank the NYU Law and Government Society and NYU Law Women. And if you'll join me in thanking not only our panelists up here currently, but the panelists from earlier this morning, I would greatly appreciate that.